Welcome to this Autism Ontario webinar, Direct Funding and Private Support Workers. My name is Matthew Lay, and as always, I will be your host. On the desk today, we have Cheryl Wiles Pooran. Cheryl, thanks for joining us.
Thanks very much for having me.
This is Cheryl's first time on the desk, and the first time that I believe I'm interviewing a legal professional. So, as you guys are used to, I've got a lot of things I need to say off the top, and today I've got one more thing. A disclaimer. So the information that we are providing today is timely. It's important information that we all need to get our head around, but what we're not doing today is providing legal advice. And that pertains to a big part of what these webinars are, is me getting you answers to your questions. You submit your questions, they come up here on my iPad, and I try and get you as many answers as I can in the 60 minutes we have allotted for the webinar. But today, just make sure we are not in a position to be handing out any legal advice. While I'm on it, we are going to be referencing a series of resources throughout the webinar. There's a bunch of them, and I'll be talking to them at different times. You can access them, as always, in the resource section. And if you have any issues at all with the technology, you can go ahead and click the Help button. Okay, that was even more than I'm used to doing. So with that out of the way, we're going to jump into this. Cheryl, thanks so much for joining us. This is, again, like I mentioned, a very timely and topical conversation. But before we dive into that, can you tell me a little bit about Pooran Law, your practice, and what it is that you do on a day-to-day basis?
Sure. So I am the lead lawyer for labor and employment law at Pooran Law. My practice is dedicated to supporting individuals, families, and not-for-profits and charities, particularly in the disability sector. So I work with individuals who have disabilities or who are on the spectrum in their employment needs. I work with families dealing with their employment-related issues, when they're engaging support workers, which is a big part of what we're talking about today.
Yeah.
And I work with autism organizations, with not-for-profit, social enterprise, charities, with regard to their labor and employment needs. So anything from hiring workers, firing workers, that does happen, union negotiations, that kind of thing.
Sounds like a fairly specific practice that you have there.
It is.
Can you tell me the origin story, how you zeroed in on this line of work?
Sure. So I personally did some volunteering as a young person in the disability sector, and really felt that it was an area that I would love to dedicate my life to. Of course, I went the Bay Street route for a little while, but it was always a calling for me to come back to doing something that I felt really meant something and that improved things in the world. And my partner, Brendan Pooran, who is the founder of Pooran Law, has family members who have disabilities and has really dedicated his whole life to disability. So his practice covers other aspects of disability law. Our firm has lawyers that specialize in a variety of different areas, but all linking to and specializing in disability-specific issues in those legal areas. So family law, wills, estates and trusts, corporate law, but for people and in the disability sector.
So today we're going to talk about direct funding. We've been talking about that a bunch here on the desk because big changes did occur. Paying for support, but you're a legal labor lawyer. Why do we need a lawyer to explain this stuff to us? Why aren't we talking to someone from the government? What's important about today's presentation that we need to bring in a professional like yourself?
Yeah, I think that's a good question. Direct funding and self-funding for supports engages a lot of employment law issues, right?
Okay.
The second we go from government providing supports or a third-party agency providing supports.
The way it used to be.
The way that it used to be, if it's a group home, if it's a day program, somebody else is responsible for hiring the workers, paying the workers, firing the workers if they need to.
Right.
And now, in this new sort of realm that we live in, the government is increasingly shifting funding away from charities and not-for-profits who provide those direct supports towards families. And that means that families are increasingly stepping into the role of employer, right? The families are the ones who are recruiting, hiring, firing, and managing workers. And so those all engage employment law issues. And what I have seen in my practice over the years is there's an increasing number of families who are having a wake-up call too late. Right?
Yeah.
When a worker has already sued them or a worker has already gotten injured on the job. And by far, I mean, that's not the majority of cases.
No.
But I think families being educated about what the risks are, what their obligations are, helps them to organize how they engage workers so that they are protecting themselves.
Right. So last time we were here, we talked about parents going from caregivers to accountants, and now we've got employers on the list.
Yeah.
Okay, so we're going to start off with the various funding types. Let's start with the Ontario Autism Program.
Mm-hmm.
What does that entail?
Okay, so Ontario Autism Program is funding that's available for children and adults with, or young people
Yep.
with autism or who are on the spectrum. And it's available and historically has been allocated on a needs basis.
Okay.
It has historically substantially been flowed through transfer payment agencies, many of whom would provide the direct support in terms of autism therapy and so forth.
Right.
For people on the spectrum. The change that you'll be very familiar, I'm sure,
Yep.
with the changes that have happened over the past couple of years. But what we've seen is a decision by this government to move towards direct funding of autism funding. And that means that parents are stepping into the role of receiving dollars directly and then having to pay out of pocket using that funding directly. So as I said, that is where we get into that scenario of, am I now an employer, right?
Yeah.
Historically, that funding was very often flowed to a transfer payment agency, and that transfer payment agency had full-time support workers or full-time behavioral consultants and so forth who were actually delivering the therapy in-house. And now we're looking at situations where that funding is being transferred away from the agencies towards families,
Right.
And then families are then procuring or buying services maybe from that agency or from others in the community.
And it's a flat rate or something like that now or something?
Yeah, so it used to be, again, as I mentioned, more needs-based,
Yeah.
and now we're looking at caps of or proposed caps
Right.
of $5,000 for older children,
Right.
a cap of $20,000 for younger children.
Yeah.
But there is still, in theory, a possibility that those caps will go away.
There's some talk going
There is
on.
some talk going
Right.
on, but we still don't have any concrete idea about what it's going to look like.
Right. And young is 6 and below?
I believe so.
Okay.
Yeah, if I recall off the top
we're
of my
incorrect,
head.
we'll go to the Autism Ontario website. All that information will be there for sure, or in some of the resources when we get to that point. But there are some special things that are in place for older adults, those on the
Yes.
spectrum that are 18 plus. We call it the passport funding. What's that all about?
Okay, so passport funding is funding that's been around for quite some time now.
Mm-hmm.
It is funding that is needs-based, and it is up to $35,000 a year,
Okay.
depending on, again, the needs of the individual, their caregiver, and their circumstances.
Right.
This funding can be used for community participation supports. It can be used for respite, and by respite I mean caregiver relief, essentially. So parents, mom and dad, want to go on a vacation for a week, the respite dollars could be used for the person to stay with a respite worker,
Right.
or elsewhere in the community with a transfer payment agency, perhaps, on a respite basis.
Yeah.
So the passports can be used pretty flexibly. It can be used for camp and that kind of thing. And this is direct funding as well, right? So the direct funding means, again, the money is going to the person. The person is supposed to use it to purchase supports,
Right.
whether that's from an agency or from a private individual in the community.
Right. And although you were telling me before that the Liberal government did like a blanket $5,000, this one is needs-based up to $35K, similar to the way everything was done before. We have a question from our audience on that topic asking us if you know how passport funding is priority determined. How is passport funding priority determined?
Right. So in terms of who's going to get it
Yeah.
and who's going to get those higher amounts of dollars, it's really going to be a reflection of the living circumstances of the person. It's going to take into account the circumstances of the caregiver. Essentially, the more closer to a crisis you are, the higher amount of passport you are going to get. Higher behaviors is very often going to translate into higher dollars as well.
Right. So it should be the people that are in more need are getting more money.
Yeah, unfortunately, I don't know that that's what we see. Very often there are folks living in a group home setting, so they've got full-time, 24/7 residential care, and they're still getting $20,000 in passport, where you might have an individual living at home with elderly parents who's getting only $5,000. So, the needs testing is not perfect by any means.
Okay. We could probably talk all day about advocacy and where to go, but we're going to move on because that's not what today's about, but maybe we'll come back and we will handle that on a later episode. There are some other places to get money, right? Some federal benefits and things like that?
Yeah, there is the child disability benefit that comes from the federal government.
Right.
Again, it's a smaller amount of funding. It's about $2,800 per year at a maximum, and it is means tested, which means that the higher your family's income, the lower amount of money you're going to get. So again, smaller amounts of money, but when you bundle all of this together, if you put together your OAP funding, and then you put together your child disability benefit and funds that might be coming out of mom and dad's pocket.
Which I imagine that a lot of people have to do these days.
Absolutely. You're getting into the situation where you might be hiring workers for quite a bit of time in any given week. And generally speaking, and as we'll talk about later in the presentation, the more money you're spending on a worker, the more hours you have a worker with you in any given week, the greater the likelihood that that worker might actually be your employee.
Right, and that's the gist of why we have a lawyer on the desk today. Okay, let's talk about the law, and let's talk about paying for support in this changing landscape. What do parents need to know?
I think that's, that is the essence of it. Parents need to know that by virtue of the law here in Canada and abroad, the laws about who is an employee and who is not an employee are pretty standard. They're pretty well entrenched, and they apply equally to a family in the same way they would apply to Walmart.
Okay.
Right? So when you're paying for support, what you're really looking at is you're either contracting with an agency, right? You're contracting with a self-employed worker, or you're contracting with an employee. Those are the three standard ways that you're going to be engaging a worker to provide supports to your loved one with a disability or who's on the spectrum. And what that looks like is it essentially creates a contract. And this is an aspect of contract law. And a contract doesn't need to be written down to exist. It doesn't even need to be verbalized. It can be
implied.
It can be implied.
What's an example of an implied contract?
Well, if we break it down into its simplest form, an implied contract would be walking into a store, picking up a stick of gum, putting it on the counter, and the worker behind the counter holding out their hand for the dollar value. That in itself is
doesn't cost $1 anymore.
Well. I'm dating myself, but the reality is that in itself it's a form of contract, right? So you don't necessarily have to make everything about your relationship with a worker explicit in order for there to be certain aspects of law implied into the relationship. One of those things would be, for instance, if a worker is your employee, and we'll talk about the test for employment, by operation of law, if you don't say anything different, if you don't write anything down differently, they are entitled to what's called reasonable notice of termination. Right? So this common law notice is what is commonly referred to as, and this applies automatically unless you do something different, unless you have a written contract that says otherwise.
Sounding to me, based on any interaction I have with a lawyer, but also in general, that it's going to be good for parents to get into the habit of having written contracts of some sort, even if they are basic and simple, correct?
Yes,
okay.
Absolutely.
That would be a recommendation.
Yeah.
Okay, there is something called the Employment Standards Act. How does that come into play with what it is that we're talking about today?
Right. So the Employment Standards Act, this is legislation that essentially modifies the common law. So, we've just been talking about what is the law, how are contracts created, and so on. So here in Ontario, we've got the common law, which is judge-made law, and we have statute. right? Statutes are written laws that the government creates. They're written down. You can very clearly go through them and see what all the various aspects of the legislation is. Employment Standards Act is a piece of legislation that sets the very minimum that every employee is entitled to. Right, and the Employment Standards Act applies if your worker is an employee, if you are an employer.
Right.
But what it includes is very clear statements that the Employment Standards Act can apply even if you have a contract that says, I am not an employee, or I don't get vacation pay, or you don't have to pay me the minimum wage. Those types of contracts that say, I'm going to waive my employment standards rights, they are not binding.
So when I pay my son's babysitter
Yes.
less than $14 an hour, am I breaking the law?
So there's exemptions for babysitters, and we're going to talk about what those exemptions look like. And
I'm not asking for legal advice. I'm just making sure that,
Yeah, there's rules for who is an employee and who's not, and we're going to get into how you break that down and how you determine that. What you see on the screen before you right now on the PowerPoint is that what we're trying to drive home here is that just because you've got a contract that says my worker is not an employee doesn't mean this webinar is not for you.
Right.
The other piece here is that there is new law under the Employment Standards Act that says it's an offense to mischaracterize a worker.
Okay.
Right? So saying to a worker, well, you're not an employee, and so you're not going to get employment standards minimums like vacation pay and public holiday pay or the minimum wage, that in itself can be an offense.
Okay.
Now, I don't want to scare families. That is not what I'm here to do.
No.
And generally speaking, families are not the targets of this type of legislation. But nonetheless, the law does technically apply to families. And I sadly have seen cases where families are getting tied up in litigation over this type of thing. So that's why we're here today.
Yeah, and we're in a gig-based economy. There's greater things at play here for the setting of new jurisprudence. So you said you're not here to scare people. And so we're going to get into something here. And this is, once again, guys, we're here to educate and inform and take you through the information. But we're going to go through a couple slides. We're not going to spend too much time on them because I think we're going to come back to them after we define things. But the key rules that families need to understand. And the first one is about misclassification. How does this occur? What do they need to understand about that?
So this is the new rule that I was mentioning, right? It is now an offense to misclassify a worker as a independent contractor or self-employed when they're actually an employee.
Right.
And we're going to spend a good amount of time today talking about how you know the difference.
Right.
But it is important to know that the government is on a bit of or has been. This government maybe not so much, but the previous government was on a bit of a tear on this issue. They had posted on the Ministry of Labour website clear statements that say things like, did you know just because you've signed a contract saying you're not an employee doesn't mean you aren't protected by the Employment Standards Act? So very employee, worker-focused legislation. So that's one thing we need to just keep in mind in the background here is that the
Where's
law...
that coming from?
Well, the law, Employment Standards Act itself.
No, I mean, call it the focus to publicly put that out there. Is there been, clearly this is not intended for parents in this situation. These are being brought up due to businesses that are abused.
Yeah, there's quite a bit of abuse out there. It's pretty sad to see. There's many employers or big companies that are making big dollars on the backs of workers they treat as independent contractors. You may recall seeing Toronto Star Blitz type coverage on some of the deaths that have occurred where workers from temporary help agencies perhaps have been treated as independent contractors. They're not receiving training, they have no benefits, they're not being paid properly, and because they're not receiving that training, there's deaths happening on the job. So this is why this type of protection exists.
And is out there so much right now.
That's right. And unfortunately, families who are not the big offenders here are getting swept up in that.
Right. But there are exceptions. You put it right here, domestic worker, RCW. What are the exceptions?
Yeah, so what you'll see on the screen here is a list of the Employment Standards Act. Again, these apply only to employees.
Right.
These are the key elements that families need to be aware of. These are the things that really create potential liability if you're not meeting your obligations on this front. So I'm not going to go into each of them. There are links at the end of the presentation that help to clarify these things.
Those links, by the way, guys, you can go into the Resource Center, and what we've done is we've aggregated all of the resources that Cheryl's put forward for us in the Portman Law Resources section. And specifically to get more information on this is the Ministry of Labor, the MOL fact sheet, a couple of the other ones, and there is an ESA overview as well in there for a compliance overview. Those are two that will help you understand a little bit more about this.
Yeah, those links are really useful. But the exemptions that you're mentioning, the RCW, that's an acronym for Residential Care Worker.
Okay.
And it's only available to families in very unique circumstances where the supports are actually being provided in a unique scenario where essentially you've got a separate residence established for your child or loved one with a disability, and the supports are being really run like a private group home essentially, or a private residential facility for one or more people with support workers coming in or residing there with the person. Okay. So I won't spend too much time going into it. It's pretty fancy stuff, and we do work with families to create these types of creative, innovative residential support options for people because we know people want autonomy. They want to live independently, have their own homes. They don't want to live with mom and dad forever. And these types of options can work really well, especially as parents are aging and that kind of thing. Yeah. They're beautiful, but they're complex. And so I don't try this at home without some advice.
Right.
Yeah.
Okay. All right, so some other important legal issues that we need to be considerate of.
Yeah.
Take us through them.
Okay, so these are, again, these are legislative protections that exist in Ontario. The first one is the Human Rights Code, and what that's really about is not discriminating against people based on their race, their religion, their gender, their ethnicity. Yep. These are the types of things that are protected under the Human Rights Code. And there is also what's known as a duty to accommodate under the Human Rights Code. Now, a family's duty to accommodate is going to be pretty limited because your resources are very, very few and far between typically as a family. So I'm not going to dwell too much on this, but it's just a good idea to know from a human rights perspective that posting a job advertisement that says we're only going to consider people of this nationality or what have you, is likely to result in some queries or questions or potentially complaints. Yeah. And there are exemptions for families who are engaging workers to provide personal support for a loved one with a disability. Yeah. But you don't want to have to explain that. So just being careful not to set off alarm bells with potentially discriminatory looking job advertisements. Questions.
Language is okay though, right?
Sorry?
Language is okay.
Well, language in and of itself, if it speaks to ethnicity or it goes to national origin and that kind of thing, and language in and of itself can be a discriminatory issue. Okay. For instance, there is a right to require somebody actually speak English, but unaccented English
would be a problem.
Yes.
What about foreign languages? Simplified Chinese, Mandarin, that kind of thing. Are you allowed to post that?
Certainly, if that is a bona fide need for the job, right? If the person they're going to be supporting only speaks Mandarin, of course, saying the person needs to speak Mandarin is going to be a legitimate work requirement.
Okay.
Yeah.
All right.
So the next couple of items here, we've got the Health and Safety Act.
Right.
I point this one out because there is some mandatory training that applies. And again, this is not designed for families.
Yes.
But sadly, there's no exemption for families either. The training is really easy to take. It's online mandatory training, and I think we've provided the links for the mandatory training in the resources section. I've never seen a family get in trouble for not providing this, but as a best practice, I have many families who do.
Right.
And it's really just about knowing your rights and your obligations to maintain a safe workplace. It's a good idea for families to take it because you might not understand this as a parent or a family member, but when you have a worker come into your home, all of a sudden your home technically is a workplace.
Right. And that's not just for employees, right? That's for contractors. That's for anyone that is coming in.
Well, contractors are a little bit different,
Okay.
but I think the key facts that we want to focus on here, most of this legislation is really about employees.
Okay.
The CRA deductions and so on, that's the next thing on the list there.
Definitely employees.
That's about employees,
Yeah.
but you wouldn't otherwise know this, but there is still, even if your worker is an independent contractor, there can still be obligations to do some filing
Right.
for the CRA about that worker. So we'll get into that a little bit more as well. WSIB, that's the Workplace Safety and Insurance
Yep.
Board. This is injury-related insurance, and under the law here in Ontario, there is actually requirements that apply for employees, even domestic workers, people who are employed by families.
Okay.
And then finally, the common law, and this is what I mentioned before. Some key aspects there are the entitlement to reasonable notice in the event of termination, freedom from negligence and that kind of thing. This is what the common law is, but in the employment context, what we're really focused on is those termination-related entitlements.
Okay. So now we've gone through all of that.
All the scary stuff.
All the
Yeah.
stuff that we need to be worried about. That primarily has to do with employees. So let's get to what I'm sure many people in the back are thinking is, when is a worker an employee? Mm-hmm. So what sort of defines that?
Yeah.
So now we get into we get into human resource or HR law. So
Yeah.
take us through this.
So it's really important to know that human rights law it does apply equally to people who are neurodivergent, people who have disabilities,
Mm-hmm.
and it applies to their parents, equally with Walmart.
Right.
Like I said, some of what we see in the employment law context is that very often families think, well, this doesn't apply to me, right? And it very clearly does. There's lots of case law out there in which families have been found to be employers and to be responsible for employment-related obligations.
Okay.
Yeah.
Example?
Yeah, absolutely. So there's situations where a worker has signed a contract and said, I'm an independent contractor,
Right.
And I'm going to get paid $25 an hour to provide these supports.
Yeah.
And, 6 years later, the worker turns around and says, you know what, actually, I think I'm an employee, and on top of that $25 an hour, I want vacation pay and public holiday pay, and that's certainly not budgeted for.
Yes.
Right? Yeah.
Okay. So when our family is employers, what's the litmus test?
Okay, so the various factors that are taken into account when determining whether or not a family is an employer or not, these are the rules that sort of come out of the general business context, and they're applied into the family context.
Right.
Because again, families, Walmart, same thing from an employment law perspective.
Yeah.
So some of the factors that we're looking at, intent is a big one.
Okay.
And what do we mean by intent? We mean, what did the parties, mom and dad and worker, think about the nature of the relationship when they started out?
Right.
Did I think that I was going to be at the mercy of the family and dependent on them, and that they were going to tell me what I was going to do on any given day? Did I understand this was going to be my job, right? That this is where I report to, this is my livelihood. That kind of thing is what we mean by intent. And the best way to express intent is really through a written document.
Right.
As I mentioned earlier, having a contract that says, I agree, I'm an independent contractor and I'm not an employee and I'm not going to have entitlements to employment standards related rights, doesn't mean that the worker is not an employee.
Okay.
That being said, it's a good indicator of what the parties thought about their status. So intent is important, but it won't trump the facts, right? So if you have a contract that says, I'm an independent contractor, but then in practice, the worker really looks like an employee and in the everyday operation of the relationship, then that contract is not going to hold up.
Okay.
Okay? So what really matters is what's happening on the ground, right?
Yeah.
If it walks like a duck, it quacks like a duck, it's probably a duck. Control is one of those factors that determines whether it's a duck or not, right?
Okay.
So control is Who's in charge of the who, what, where, and when of the work? Who schedules the work? Who says where the work is going to happen every day? Who says what meals are going to be created? What kind of services are going to be performed? Where they're going to be performed, and so on. The person who gets to make those decisions is typically the person who's going to have more control in the relationship. The person with more control is typically the person who's the employer, whether it's the worker. If they have more control, they're self-employed. If it is the family who has more control, the family starts to look more like the employer.
Okay.
Now, none of these factors is, an a fait accompli, right? None of them is going to be, determinative by themselves. Ownership of tools is another one. Obviously, it sounds like it comes out of the business context.
Yes.
We're not talking about hammers and nails here, but we might be talking about training materials, right? So if we're talking about some autism therapy, for instance, if the therapist that you've hired is coming in, bringing with them all of the tools and resources they need to deliver that therapy, then that starts to look more like they are self-employed because they're making an investment in having those tools, creating those tools, purchasing those tools, providing the supplies. That looks more like a independent contractor or a self-employed person.
Right.
On the other hand, if the family is providing everything and the worker really just has to show up and do what the family says on any given day, again, that's looking more like an employee. Risk of loss, chance of profit, that again looks a lot more like the business context, but if we apply that into the family context, what we're really chatting about is, again, is there some kind of an investment being made by the worker in the work? Right? Are they bringing with them any tools or resources? Are they giving up the opportunity to work for others? Right? Is there an opportunity?
That's a big one, isn't it? Because I know that you can't be a contractor if you only have one client.
Right.
Right. Like you'll get, if you say you're a contractor, you'll get pinged by the CRA if you only have this one customer you're working for all the time, correct?
Yeah, it happens, right? There's lots of folks out there doing that kind of thing. In the family context, essentially the greater reliance that the worker has on the family for their livelihood, the more likely they are to be an employee. So, for instance, if they are working for a family 40 hours a week, it's looking a lot like an employment relationship. If, on the other hand, they work for one family on Mondays, they work for another family on Tuesdays, they work for 3 different families on Thursday and Friday, that starts to look more like a typical self-employed person.
Right.
And there's a blurring of the lines here, right? It's a spectrum. There's not any one determinative factor. But certainly when we start to get into a situation where a worker is dependent on a family for their livelihood, if that family fires them or lets them go, and there isn't, and therefore they lose that income and they can no longer support themselves, that's starting to look like the type of scenario where a court, the CRA, Ministry of Labor, is sympathetic, is more likely to find that worker to be an employee.
Right. Exclusivity, we see it on the track as well.
Exclusivity is a big one. The pay arrangements, so a typical contractor is invoicing. Right? As opposed to just getting a default payment, family managing a timesheet and then paying out a check or payroll of some kind, as opposed to the contractor saying, well, here's my invoice and now you're going to pay me within 2 weeks. Right? That's a more typical arrangement, and certainly having an invoicing system is a recommendation if you're going to try and characterize that relationship as an independent contractor relationship. The employment type arrangements for the work that's happening, so the scheduling procedures, how the worker is being trained and so on. If a family has a bunch of employees, for instance, and then has one person that they're going to treat as an independent contractor, that starts to look a little bit questionable. The law is going to be a little bit more skeptical about this because generally if you've got one person being treated as an employee and another person being treated as an independent contractor, and they're both doing the same work under the same conditions, they're both going to be treated as employees.
And that's part of what's going on the broader scale that's causing some of the some of the magnifying glass to be on companies anyways,
That's
not,
right.
not families. Got a couple questions from our audience before we continue to move on. First one, how much notice should an employee be given upon termination?
Yeah, that's a great question. It's really going to be driven by the terms of your employment contract. That's a big determinative factor in what you're entitled to on termination. If you don't have an employment contract, then the very minimum you're entitled to, if you've been let go without just cause, is going to be usually range between 0 and 8 weeks notice per year of service under the Employment Standards Act, plus potentially severance pay, which depends on the size of your employer and how big their payroll is. Right. If you don't have an employment contract, on top of the employment standards minimums, there's also something known as reasonable notice of termination, and that can range between 3 weeks to 6 weeks per year of service, depending on your seniority, how many years of service you have, how high level that your position was, your prospects for reemployment. All of those are factors that go into it. There's no hard and fast rule that says what any individual is going to get. Now, of course, this only applies if it is a without just cause termination. In the event of termination for just cause, you're looking at 0. So that's something to keep in mind.
And the ESA website, which we've referenced before, and I'll reference it again, is where you find this information. If you are in a complex situation, do not do this at home. All businesses have lawyers and HR professionals that they consult, and you should do the same. Yeah. Next question before we move on to examples of workers who are employees. If the therapist requires supervision, does that make an employee or an independent contractor, and why?
Okay, that's a great question. So you'll see typical examples of people who are or are not employees. The therapist is in an odd situation, right? Because very often they come into the relationship with skills and training and knowledge that the family does not have.
Correct.
So it's a little bit more like, this is a really basic analogy, but it's like when you call your electrician.
Yes.
This is somebody that you don't typically have the ability to supervise. You're just like, I'm hiring a professional. Yeah. Come on in, do your thing, and make it work. And very often a therapist is in the same boat, right? A therapist has that training. So the expectation is they come in fully loaded with whatever tools and resources they need to do the therapy, with all those skills. Mom and dad are typically not directing, controlling, supervising.
Yeah.
If we start talking about supervising the therapist, I tend to wonder, is this really a therapist? Because, typically the definition of a therapist is that they know what they're doing without mom and dad directing them. Now, very often in autism services, mom and dad have received perhaps just as much training or have more life experience and knowledge about what their child specifically needs in the therapy context. So, an orientation to the needs of the child, perhaps, and even involvement in the therapy isn't necessarily going to make the therapist not be independent, right? Just because mom and dad are participating, I think we have to draw the line between an orientation to needs of the child, participation, and therapy.
Directing to therapy.
That's right.
So this goes back to the other litmus test of who is directing what's going on.
Right.
Regardless if this parent has to supervise or feels they need to supervise this therapist, if the therapist is driving the therapy based around their training and everything else, then they're an independent contractor.
That's right.
Okay.
Now, when, a big factor there is going to be around the exclusivity of the relationship too, right? Very often a therapist is working with multiple children, she's managing her own schedule, and really creating her own ability to make a livelihood out of doing this work, because she's able to say, well, you know what, I'm going to work with so-and-so from 4 hours in the morning, I'm going to work with somebody else for 4 hours in the evening, and cobble together a full-time job, right, out of the therapy. And that ability, that control and ability to create her own life balance is going to be determinative of that, or help to determine that person is self-employed. If we're talking about a therapist who is working full-time with a family for a year,
that's got to be an odd.
That's looking a lot like an employment relationship.
That can't happen very often with a therapist.
Well, there are those individuals out there who have $80,000 a year or historically had $80,000 a year in funding. We know that's not necessarily happening anymore,
Yep.
but certainly there's room there for 2 full-time therapists at that rate, right? So it is possible that could be therapists being, having a 40-hour a week with one family.
Yeah.
But, treating that person as an independent contractor, even though they're a therapist, is still going to be risky because you've got those factors of exclusivity, dependence.
Yep.
Those are big drivers for decision makers when they're determining who's an employee and who's not.
Clearly, the more money you're spending, the more closer you're going to be tied to this.
That's
okay,
right.
so we got some examples of workers being employees, some real life examples. Take us through these and
Right.
what we should know.
So a sitter,
Yep.
babysitter is the common word for it, is somebody who provides occasional care for a minor, a few hours here and there.
Yep.
They're generally not an employee. I think all parents out there are feeling pretty good about that one. Live-in support and live-out nannies are generally considered to be employees because, again, we typically are having that degree of exclusivity that comes along with it. Nannies and live-in support workers are typically at the mercy of the family, right? They're being supervised, even if they're not supervised because mom and dad aren't home all day, they're still being directed heavily by and controlled in terms of where, when, how, and what the work is by mom and dad, right? Therapists, tutors, coaches, and professionals, again, typically are not employees because they have that control. They are typically have multiple clients. They're not in that exclusive relationship. Barring aside those cases where we've got $80,000 going to one family and they're spending it all on 1 or 2 workers, then we might be having a different story. But generally speaking, they're going to be independent, self-employed, unless they're working for an agency.
Yep.
Right? Full-time support workers, again, usually an employee, and that's because they're full-time. They're dependent on the family. That exclusivity is there, and usually with that comes the control and so on as well. Part-time support workers is really going to depend on the regularity of the relationship, the hours worked, and that dependency factor. If we've got somebody who's working 1 day a week, and they've got lots of other clients that they're working for, they've got a full-time job elsewhere, and this is just a side gig where they say, hey, I have 5 hours here, I can work for you. Mom says, thank goodness, yes, please come and provide some support. That's starting to look more like a self-employed person, or it's not that, it doesn't tend to look as much like an employment relationship. Respite in a respite provider's home is usually not an employment relationship. The reason being, usually that respite provider's got all the control over their own home. They have a fair degree of ability to say yes or no to the work. They have, again, usually their own self-employment and so forth. Respite work in the family's home is, again, just like the part-time worker, is going to depend on the degree of dependency, the exclusivity of the work, and how regularly it's happening. A respite worker, who's coming to your house every day of the week is not really a respite worker anymore, right? This is just a full-time employee. But, respite that happens for 1 week a year when mom and dad want to go on a vacation, that's probably not an employment relationship.
Yeah. So I'm feeling a lot better, not only about me not breaking ESA with my babysitter, but also just in general, because it sounds to me like, number one, you're probably spending a considerable amount of money if you're in the employer situation. And number two, it really comes down to the amount of time that these people are spending with you. And it seems like there's a much clearer divide than, when I was first looking at those slides. And although we know that there's risks, before we move on to the risks, I do have one question. If I've got someone who I believe to be a contractor, and I found them and I'm giving them, let's say, 2 days a week or a day and a half a week, but that's their only income. They don't have other clients. They just have me or my son as a client. Do I have additional responsibilities to them because this is the only, even though I'm not paying them enough to live in today's world, do I have additional responsibilities to them because they don't have other customers? Clients?
It could create an increased risk of them being your employee. When you think about it, the kid who works for 4 hours a week at the Gap is still an employee, right?
Yes.
And so, just because it's only a few hours doesn't necessarily mean it's not an employment relationship. What do we want to do with that, right? and I think the reality is that we have to look at risk not just from the technical rules about who is what, but also what is the scope of exposure, right? So with a person who only works, let's say, 8 hours a week,
Yep.
The risk is lower because A, they're less likely to be found to be an employee.
Right.
But also because even if they are found to be an employee, the scope of the exposure is lower because vacation pay and public holiday pay is calculated based on how many hours you
Yep.
work and what your pay is. So if you're dealing with a worker who's working 40 hours a week and earning $1,000 a week, let's say, vacation pay and public holiday pay on that is going to be a lot higher than it is on somebody who's only making $100 a week.
Right.
Right. So the amount of exposure is just a lot lower.
Okay.
And the workers themselves don't tend to think of that sort of casual, occasional type of work arrangements, even if it is steady one
Yep.
day a week. They don't tend to think of it as employment. They don't tend to think of it as this is my job and I have employment-related rights.
Yeah.
The same way that a worker who's working for you full-time is probably thinking about it. We don't tend to see complaints being filed by workers who only work once a week.
Okay.
The exception to that might be where they get injured on the job. And that type of scenario can drive people to do dramatic and uncharacteristic things, right? And I think that's really the crux of it, is that generally speaking, your workers are not out to get you, right? They're not trying to make bank by pulling one over on you, saying they're an independent contractor, and then claiming more.
No.
That's not what workers are out there. Most people who are working in this sector are really good people with strong values. They're very empathetic with family circumstances and so on. Usually the types of scenarios that are going to drive people to make complaints against a family is where they are themselves driven to extremes by an injury or because they are dependent on you for their livelihood, and that goes away, and they're desperate, right? So what in an ideal world we're doing is structuring the relationship so that that doesn't happen. Right.
So this leads really well into this next question because I knew it was going to come up at some point in time. Yeah. I almost made a joke about it earlier, but what if the worker is a family member and varies in respite hours in the house and out of the community? Do parents need to treat them as an employee and pay CPP, WSIB for them?
That's a tricky one. I think it is very uncommon for families to treat family members as employees. And certainly for passport dollars, there is an ability to pay that money to a family member, not the parents, but to other family members. And
there still would be a contract and that would be in place, right? Just because they're family doesn't mean that they're not
it's true.
one of the two, right?
I think that we look at a couple of things. We look at the big thing is, what is the risk?
Right.
Is that family member going to report you to the Ministry of Labor? Probably not.
Right.
Are they going to report you to the CRA? Probably not, because they're pretty happy getting that money under the table.
That's right.
Are they going to sue you? Probably not, right? And even if they want to sue you, it's pretty likely you're going to be able to work that out, having other family members perhaps intercede and solve the problem together. So I have received this question before, and there isn't any easy answer. The technical answer is probably, you should be treating them as an employee if they're working that full-time contingent, if they're checking all of those boxes from a employee perspective. Technically, yes. Practically, you got to just think about the nature of your relationship and make a calculated decision as to whether or not you think you want to go through with the formalities of the employment relationship. And certainly there's ways of reducing your risk, and we're going to talk about how to reduce the risk throughout.
Right. Mom, if you're watching, don't get any ideas. All right. So risk.
Yes.
Mitigation of risk is what we all have to do. What are the things that people should be worried about, I guess? Or what are the risks?
Yeah, so, I don't want anyone to necessarily be worried.
That was poorly worded.
Right? What we want is people to be aware of what could result in complaints being made. So there's a couple of different forums that complaints can be made in. Revenue Canada, Canada Revenue Agency is one of them, and that was one of my very first cases involving a family way back when. It was a family who had somebody working with them as a live-in caregiver, 40 hours a week. week in and week out and had treated her as an independent contractor. She was let go for, of all things, leaving the gate to the pool open and unlocked with the person with a disability, in the backyard and so on. Big risk. So quite rightly, mom and dad said, your employment is, or our relationship is over.
Yep.
And they hadn't been making deductions or remittances to the CRA. When that relationship came to an end, the worker said, well, I want EI. Of course, there was no EI because no remittances had been paid. So in that case, Canada Revenue Agency came after the family. And that is typically the only way that CRA finds out about these types of relationships. Very often it's because the worker then goes and says, relationship is over, I need EI, and there isn't any.
Yeah.
Right? Ministry of Labour is the other forum that workers typically go to, and that is what I see most often, is claims being made to the Ministry of Labour, because there's no fee for going through that process.
Yeah.
You don't have to have a lawyer, you don't have to pay anything to file a complaint, and the Ministry of Labour actually runs the show for an employee. They are really there to protect workers, right? So they do it all, and workers don't have to worry about anything. And the amounts that a worker can get through the Ministry of Labour tend to be smaller than what might be available through a civil court procedure, but it's easier to manage for a worker. So we do tend to see Ministry of Labour complaints typically around termination pay, vacation pay, and public holiday pay. Those are the big ones.
Yeah.
Okay. WSIB is another where a worker gets injured on the job, and they were required to have WSIB. The family was required to have WSIB. They didn't have it. Worker gets injured, and who's going to pay the bill?
Okay.
Right. That does not happen very often, but it's always a possibility. So it's something to keep in mind. And then finally, civil liability, which is small claims court actions, and we do tend to see those happening as well, because don't judge us, but there are a lot of lawyers out there who take claims on a contingency basis, which means the worker doesn't have to pay out of pocket, and the lawyer will advance a claim. They write a letter to the family, and family doesn't pay up. Then we're off to the small claims court or the civil courts. So most commonly, these types of complaints are coming up from a worker who, as I mentioned before, is desperate, right?
Yeah.
You're not typically seeing these types of complaints being filed by a worker who is currently engaged, currently being paid by a family. They don't want to rock the boat, right? So we typically are not seeing these unless the worker is let go, right? The other time that we sometimes see these is if a claim is being made to the CRA, or the worker has reported something on their T4 that sends up alarm bells for the CRA, right? So and that can be when somebody who's treated as an independent contractor, reports earnings or something, and the CRA turns around and says, well, where's your T4? And the worker says, well, I don't have one. My employer didn't give me one. And that's when CRA comes knocking.
Okay. I'm going to ask you this question, and then we're going to have to move it through our best practices, okay? Is an employer allowed to tell a therapist, professional tutor, etc., that they are not allowed to work for another employer?
So that's a good question. That's what we call a restrictive covenant that might be in a contract. It's not very common to see those types of things. Sometimes we will see them, and we typically only see them in competing work environments, right? So I'm an IT developer and I'm working on a top secret program for one company. My company does not want me working for the competitor, right? We don't typically see it in a family context, but there is nothing stopping a family from doing that. The circumstances where that is going to be enforceable is typically where it doesn't stop a family or doesn't stop the worker from being able to earn a living, right? You could, if I struggle to understand where that would be coming from.
The only thing I can think of is full-time, and you don't want them coming in tired, so they can't go at night and do another moonlight in another job, but then it's a standard employment contract, right? That's what it comes down to, I would imagine.
And I think you're going to probably have difficulty enforcing something like that, because what the courts call it is an unreasonable restraint on trade. I know that's very businessy language, but that's typically reasons why a court would find that a non-compete is unenforceable. You could, the way to typically deal with that if you're a family and you're concerned about your worker coming in late or coming in exhausted and sleeping on the job or what have you, is as a disciplinary issue, right? This is a performance management issue.
You have to find another therapist in that scenario. Okay.
Yeah.
We're going to move on here about, we know the difference now.
Yes.
And we're talking about making informed choices.
Right.
Independent contractor, employee, staffing agency, novel models. So let's get into independent contractor.
Okay. So most people would prefer to go the independent contractor route. And here's the reasons why. So you see on your screen now, all of these bullets start with the word no.
Yes.
Because there is very little in the way of responsibility to an independent contractor.
Yeah.
They are responsible for filing their own taxes. They're responsible for their own insurance. They are not entitled to vacation or public holiday pay. You don't have obligations around WSIB. So it's very restricted in terms of what families have to do when they have an independent contractor.
Right.
There are still best practices,
okay.
right? So on your next slide, you'll see some recommendations. And there's a lot here, and it's not like you have to do all of them, but every little thing helps, right? To either A, prove the person is an independent contractor, or B, help to protect you when dealing with the independent contractor. Vulnerable sector screening is the pinnacle of both options, of employment and independent contractor. A vulnerable sector screening is essentially an enhanced criminal records check.
Okay.
It's what you can get when your worker is going to be working with a person who is vulnerable. Right? That way you know a little bit more about their criminal background, if they got any charges pending, if there are conditional discharges on their record. These types of things are going to show up, and you're going to know if this is somebody that you really want working alone with your loved one. Right? A contractor agreement is always a good idea. Remember that intent, it's not determinative, but showing what the intent of the parties was at the outset is going to be helpful. You can include requirements around the worker having insurance. Typically, if you're dealing with a therapist or a professional, they're actually going to have insurance, and it's a good idea to make them prove it, right? If they are self-employed, that's typically something they're going to have as a professional. Some of the other things that it's a good idea is to make sure that they know they are responsible for remitting their own income tax, that they're not going to be getting a T4. If it's a good idea to require invoices as opposed to keeping timesheets. So they invoice you, you get a bill, you pay it, and you keep your records. They sign off saying, yes, this has been paid. Just like you would with your plumber or your electrician, right? Then keeping the records is a really good idea. The last thing I'll mention here is that if the relationship changes over time, it's important to keep that in mind, because many families that I work with start off with a worker or a therapist and it's handy-dandy, it's only one day a week or a few hours a week, but the person is so wonderful and has such a wonderful connection with the loved one with a disability.
It increases.
Exactly, and all of a sudden you're at 40 hours a week and the person's not working for anybody else anymore. You got to make the switch at some point.
Right. All right, agency workers.
I think we skipped over. Oh. We may have skipped something in the slides, but that's all right.
All right.
I can speak to it even without the slides.
That's a professional we have here, ladies and gentlemen. That's a professional. Employee we skipped somehow.
Right. Okay. So the employee option is basically the opposite of independent contractor. You'll recall the slide that said no, 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 no.
Yes.
On the employment slide, it would say yes, 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 yes.
Yes to all of these things.
That's right. So you do have obligations around deducting and remitting to the CRA. You do have obligations to pay vacation and public holiday pay. All of those things start to apply. For WSIB perspective, if the worker is working for you more than 24 hours a week, WSIB is actually mandatory. So we're starting to get into scenarios where there's a lot more going on. There's a lot more responsibility on families. And that's typically why they don't want to go this route.
Yeah. And in most places, like in my business, and people that are contractors, they want to be contractors. There's so much tax incentives for them to do so, managing their own calendar and that sort of thing. Do we find in this world that more people want the employee relationship? Like, so we're in a situation where the person wants the employee relationship, where the employer or the families want a contracting. Are we at that juncture or not really?
So many families, after talking to me, want to go the employment route. They realize, oh yeah, that's 40 hours a week. let's make you an employee.
Yeah.
Very often the worker will refuse to do so because they love getting paid under the table. And that's a good reason why we don't actually tend to see very many complaints to the
Right.
CRA.
Yeah.
And this doesn't actually come up that often
Yeah.
because workers are happy not to have their income reported, particularly if they have multiple jobs. They like not having their income reported because their other jobs are already being taxed.
Yep.
Their income from you would likely be taxed at the highest marginal tax rate because it's over that,
Yep.
that threshold. So when we start to look at those types of things, you're right. There can be a sort of a dichotomy where parents are actually the ones who want to treat the worker as an employee and the workers don't want to.
Yeah.
The reason that there's still best practices. If you choose to go the employment route and your worker comes along for the ride, then that's great. Still do the vulnerable sector screening, still do an employment contract.
Yep.
And the most important part of that employment contract is a termination clause that says your entitlements on termination are going to be limited to the employment standards minimums only.
Okay.
Right? What you're really trying to do there is cut off that common law notice, which can be unpredictable, right?
I got to apologize to our audience. I have not done a good job managing time, and we have a couple other things that we want to get to. So we don't often do this. We're going to go a little bit long today, guys. Not too long, just a little bit. And because I keep having questions. And a quick one that I do have is in any of our, like when people are looking to do this for the first time, I know often when I need to draw up something for the first time, I go to Google and find it. In any of the resources, do you have sample contracts, or is that something that the government provides for employees, contractors?
In terms of contracts, there's not a whole lot out there. Our firm is actually working on a free book together with Community Living Ontario with funding from the Law Foundation that will be available to families for free online that will have templates in it.
Nice.
Unfortunately, it's just half-baked still. So
Half-baked?
it's coming along.
Well, it's coming. Well, some people are watching this and it's archive on demand, and you can go to the website and check for updates on that.
Absolutely.
Okay.
So I'll run through these next slides
Please.
really quickly if you like. So there's many families out there who say, you know what, the independent contractor route just seems way too risky. The employment route just seems way too much work. I don't want to go there. What are my options? And an agency is an option, right? And that would mean that you're essentially purchasing supports from an agency provider in the community, if there is one, right? And that could be a temporary help agency, it could be your local autism services organization, what have you. And in that case, this can be an excellent option. They're taking care of everything. You're kind of going back to the old school style, although you have more control over the schedule, over who you're choosing to work with your loved one, and so forth. Right? So there's pros and cons here. The con is that it tends to be more expensive than doing it yourself, although if you're meeting all your legal requirements, the costs tend to sort of balance out.
Plus, you get time back, right? It's easier doing it this
You're
way.
no longer the accountant.
Exactly.
Right? So many families will go this route and they'll just pay it up, and it can be great. Some of the recommendations we have, make sure you're using a reputable agency. And the reason I say that is that there's a lot of mom and pop shops out there, and I'm not knocking them.
Nope.
They can be great. Just make sure that they have WSIB, that they are treating their workers as employees as opposed to independent contractors, because that risk can transfer from an agency to a family if the agency is not paying their workers properly. So, and the WSIB piece is really important because you don't want somebody getting injured in your home. Very often your home insurance will not cover that. Right? So these are things to keep in mind. Making sure that an appropriate agreement is in place with that agency, because sometimes you would not believe the agency contracts I've seen that say things like, you can never sue us no matter what, right? It's probably not enforceable, but still you don't want to be signing something like that.
Exactly.
Keeping your records really clearly is a good idea when you're working with an agency. Providing advance notice when you want to terminate that relationship, still a good idea. Okay.
What is a novel care relationship?
Yeah, so there's some interesting creative solutions that families have come up with that, some of these things that we're working with families on. Home sharing is one of them. Home sharing is an option where families are, again, creating these innovative residential options for their loved one, and they have a basement apartment and they would love to have that occupied by somebody who is not actually a worker providing supports per se, but is available in the overnight period if there's an emergency, that kind of thing. And that can be great. What we want to be really careful with is just making sure that we don't blur the lines and then that worker who's living in the basement is not a worker but is becoming a worker, is becoming an employee. And we just want to be careful to not blur those lines, keeping things pretty neat and tidy. This is the only role you have with us, which is essentially responding in the event of an emergency overnight, as opposed to, oh, can you also provide a couple of hours of support in the morning and then a couple of hours of support at night? Then you're getting into, well, that whole relationship is all employment, right? And we want to just keep
now
that
it's like
clean.
a nanny living in the basement.
That's right, right. Microboards are another option, and this is something that is developed in Ontario, big in BC.
Okay.
I think they have something like 2,500 microboards out there. It's pretty impressive. The microboards are a small not-for-profit corporation, actually, that's created by family members, typically, to provide a circle of support for the person with a disability or who's on the spectrum, to provide them with decision-making supports, financial, administrative supports. The microboard can actually be the employer and help to insulate the people who are part of the microboard or the family from liability towards any workers that they might take on to support the person who is the focus of the microboard. The microboard can also be the landlord of sorts if there is an innovative residential option being created. So a bunch of perks to that. The biggest advantage of the microboard is it creates longevity. Right, so we do have an aging parent group, especially for individuals who are older. Their parents are even older, obviously, and parents are very concerned about what does the future hold. What happens when I'm no longer there to be the employer, to pay the worker, and so on. Well, the microboard gives formality to what very informal circles of support that exist now.
So it doesn't all fall apart.
Exactly. It can carry on. The employment relationship carries on. Any tenancy arrangements just carry on without there being an interruption that you might otherwise see if mom or dad become unable to provide that support and act in that function anymore.
And once again, that would be something that would generally be in place with the higher, like you're going to be in a situation where these people are spending the $80,000, $90,000 generally speaking.
You're going to need more dollars typically in order to justify this type of thing.
Yeah.
But that being said, it's not just about the money. Very often people are putting it in place just for the sake of formalizing that network around the person in question. The statistics show that these types of formalized relationships last, right? Where they might fall apart if there isn't that formal entity.
This is one more of those do not do it yourself at home, though, right?
No, but Microboards Ontario is a new not-for-profit agency that was created by grassroots folks from around the sector, Pooran Law being a partner in this process, that's designed to provide resources and information to families for free or at a discounted rate to allow families to create their own microboards in the hopes that we can create those long-standing support networks for people.
Excellent.
Yeah.
Cheryl, thank you so much for today. It was packed full of information. I'm sure that there are many questions that you guys asked that we did not get a chance to answer. And as always, Autism Ontario, probably with the help of Cheryl, will try and get those questions answered for you afterwards. That is not only all the time we have, it's more than all the time we had for today. But I'd like to thank Cheryl for your participation. I'd like to thank all you guys for coming out today. This will be archived, available online later on this afternoon or tomorrow. So you can come back and watch it again for anything you missed. And also telling your friends, family, loved ones, anyone you think might be interested in this topic to go ahead and watch the archive. The more people through these webinars, the more funding we get to put on these webinars. So with that, I'd like to thank you for your time, and I'll see you next time at an Autism Ontario event.